Thank you for being here with us, Michael. We appreciate you being here today. Shayna Finkelstein, who many of you likely already know, is currently a staff attorney for the Senior Citizens and Family Law Unit for Coast to Coast Legal of South Florida. She's been an invaluable member of Coast to Coast Legal since 2018. Shayna works with the Family Law Victims Crime Unit, representing victims of intimate partner violence. Shayna assists her clients with injunctions for protection, divorces, unlawful detainer, immigration cases, and assist them in getting public health benefits, housing, or any other legal related issue. Shayna worked for 2.5 years as a public defender in Miami prior to her work now, where she found her passion for holistic representation. Working for the Public Defender's Office provided Shayna with extensive trial experience, allowing her to develop her courtroom skills, which we see all the time now. Shayna is a double Gator, having received both her undergraduate and her law degree from the University of Florida. Shayna is a member of the Broward Domestic Violence Council and the Domestic Violence Prevention Subcommittee, as well as the Broward Victims' Rights Coalition. Shayna has always been passionate about helping individuals who could not afford to retain an attorney to represent their needs, rights, and interests. Thank you to you both and welcome.
Thank you.
Thanks for having us. This is great. So, Stacey, do you want us to just start? We kind of worked out.
Yeah, if you would, and for everyone who's here listening, you have the ability to put questions into the notes, and Michael and Shayna will present to us, and then I will go through the notes and we'll have a little time to ask some questions. I'm going to save those until the end instead of while they arise. So go ahead.
Great. So I'm going to start, and I'm going to kind of give some background on Greyson's Law and kind of how we got to where we are now. And then I'm going to tag in Shayna, and she's going to kind of get into the nuts and bolts of the current state of the law. So again, I'm Mike Rico. I had the pleasure and honor of serving in the Florida State Legislature from 2018 to 2022. I did not get voted out of office. I chose to not join the super minority and came back to Miami Beach. I'm running for office now. So I was the initial sponsor of Greyson's Law when this idea first got pitched to the Florida legislature. It ended up that Ali Kessler, who I still consider a dear friend, I got introduced to her by some mutual contacts with whom I went to college with. And from there, I heard her tragic story back from 2021. So for those of you that aren't familiar, Ali Kessler was the mother of Greyson. Greyson tragically passed in a murder-suicide in which somebody that she had dated previously, he not only killed himself, but he killed Greyson. And the unfortunate circumstances leading up to it and what led to this legislation is that this was preventable. And there are stories like this all over the country where these are preventable deaths, whether it be a murder-suicide or just strictly the murder of a child, where somebody gets it in their head, like that's their way to punish somebody for either leaving them or refusing to reconcile with them, or just out of pure anger or mental health issues. And in this case, the lead up to Greyson's death was in the courtroom. And it was a product of credible threats that were made against Ali from the gentleman, the father of Greyson, to where he was directly threatening her. He had put a tracker on her vehicle. He had threatened her physically. He said that her head should be removed from her body. I think they even had it in writing. And I don't even think that they were denying that he said this. But when they went to court, and this was in Broward County, when they went to court, the judge at the time made a determination that threats against Ali were not, we couldn't conflate the issues and say that threats against Ali could be transferred over to any sort of risk to the child. And, these emergency efforts to remove the child from the home ended up, being denied. And the result was that only days later, they found out, after silence from both the father and the child, they went to the home and found out that he had shot the child and turned the gun on himself. So when Allie came to me, I served on both judiciary. I was the ranking minority member of the Criminal Justice Committee for 4 years. So as both an attorney who, even though I do criminal defense work, I still dabble in the family law space because of the quasi-criminal status of a lot of these domestic violence injunctions. It was brought to me. We carried it in the House. It got through a few committees, but there was some pushback from the family law section at the statewide level from the Florida bar, and it wasn't embraced. It was fought left and right. We tried, I think, 2 years to pass it, unsuccessfully, because all we were trying to do was to get two things into law. One was to allow circumstances like this, to put it in statute, that judges could use circumstances like this as a mechanism to remove a child from a home, or to discuss visitation or custody. That was number one. And the other one was just simply getting coercive control, which was a term that had never even been mentioned in Tallahassee, and trying to get that part of the conversation and potentially get it into statute. I tried to do it in 21. I tried to do it in 22. And then finally, after I left, and I continued to lobby from the private sector, not in a formal capacity, but kind of behind the scenes, in 23, it finally passed, or at least a version of it passed. And as of July 1st of this year, it's now effective law in the state of Florida. And it was a proud day. We worked tirelessly for years on this. And, I'm going to tag in Shana at this point to kind of go into the nuts and bolts of what the impact will be moving forward in the family law space. And again, if you have any questions for me throughout the process, please shoot them, and then we'll address them at the end. And thank you again.
Thank you so much. As they said, my name is Shana Finkelstein. I work at Coast to Coast Legal Aid. I work in the family law unit. So the majority of my cases are injunctions, divorces, paternity cases. But I also specialize in seniors as well. So that's really where I'm going to be taking my experience from since this law change in July. There haven't necessarily been a lot of contested hearings that we've been able to see how the judges are actually going to rule based on these law changes, but we certainly are able to control our practice in terms of what kind of evidence we should present now that these things do exist in the law. So the first area of the law, obviously, that it's going to affect would just be the family law cases, the divorces and the paternities. And so what the Greyson's law added is that in addition to just evidence of domestic violence that has already occurred, being a basis to not award shared parental responsibility, now they've also added reasonable cause to believe that you're in imminent danger of becoming the victim. And now this is obviously a factor that already was part of injunctions, was that if you could show that you had reasonable cause to believe you were in imminent danger, you could receive an injunction. But in the family cases, unless you had shown evidence of actual domestic violence, often the court was not going to view that as evidence of detriment to the child. And so that's really going to be the significant difference, is that in the family cases, for us to start presenting some of that evidence that as domestic violence practitioners, we were already trying to present in injunction cases. So as Mr. Grieco touched on, it's that new factor of coercive control. So as domestic violence practitioners, we were already looking to something called the power and control wheel. I'm sure many of you have heard of the power and control wheel. What this is it kind of shows the different ways that an abuser can exhibit coercive control in order to abuse the petitioner. That doesn't necessarily amount to physical violence, but that it could escalate to that point. And so as practitioners, we were frequently trying to convince judges when we would see these things that were happening that an injunction should be granted, or that parental responsibility shouldn't be shared, that the party that's being abused should have decision-making authority at the very least, because they don't feel comfortable exercising their opinions with someone who has been exhibiting a pattern of coercive control throughout the relationship. So I think what it's really going to come down to is, how do we prove it, right? How do we prove coercive control? Or that they're in reasonable cause to believe they're in imminent danger of becoming the victim of domestic violence. So one thing that's going to help, I think, with injunctions, as far as with this new factor added, is in the past, when a petitioner was being what many people would believe is stalking, in terms of like the common knowledge of what you would think is stalking, they would struggle to get an injunction, because stalking is a very difficult definition to meet. For stalking, you have to prove that a person is engaged in a course of conduct directed at another person with no legitimate purpose other than to harass or annoy, and which is likely to cause and does cause substantial emotional distress. So yes, that's a mouthful. And what this factor now adds is that now the legitimate purpose and the substantial emotional distress requirement. So often, if a petitioner was claiming that they were receiving unsettling, disturbing messages from a respondent, but that the messages related to care of the child, seeing the child, things like that, the court would view that, well, that's a legitimate purpose, right? And so then therefore they wouldn't grant the injunction if that was the sole basis. But now this factor, which is included in the new injunctions, that says evidence of a pattern of coercive control, that's the legislature telling us what we kind of already knew all along as domestic violence practitioners, that evidence of this pattern of control is what leads to domestic violence, and it does lead to fear in the petitioner. So the way that we prove it. So Mr. Grieco actually touched on some of evidence of coercive control. One of them being a GPS device. I see that in a lot of our cases. Sometimes the petitioner is aware they're being tracked, and sometimes they're not. Sometimes the respondent openly tells them that they're tracking them, right? And tells them where they can go, when they can go, things like that. Or sometimes the petitioner is suspecting that they're being tracked. So a lot of times, if I have a client that isn't sure, I'll tell them to go to a mechanic or a body shop and ask them to check the car to see if there is a tracking device there. Or I'll tell them to take their phone to, the smart guys, the Geek Squad, whatever it is, and ask them if there's any tracking on their phone that's going on. All right. Because that clearly is showing that they're trying to control where you go, when you go, what you do. All right. Another example would be if they're denying or restricting their access to the bank accounts, to credit cards, if they're destroying property, if they're threatening to abuse pets, or they are abusing pets. These are all examples of ways that they are manipulating the petitioner or the parent, depending on whether you're in an injunction or a family case. Other ways I've seen is they show up at their job unannounced, and they try to jeopardize their job, because often the way that they are controlling is they're trying to give that petitioner or that other party nothing outside of their relationship with them. So they try to isolate them from their family, from their friends. Sometimes they don't want them to work because having work gives them financial independence, which is something the abuser doesn't want the other party to have. Another thing I've seen, especially with today's technology, is, demanding access to passwords, having surveillance videos up in the house, like in order to monitor what the other party is doing all the time. And with the way technology is now, sometimes I honestly can't tell when my client is telling me what their concern is, whether or not that is possible or not. With technology now, so many things are possible that sometimes I don't know whether my client is being delusional or if it's really happening. So take your clients seriously, because technology is only getting scarier and crazier. So try to listen to your clients and try to find the proof of that. And sometimes the proof is going to be, you know, where we've always tried to look for proof in these cases: text messages, WhatsApp messages. I would recommend, if you're already within a case, that you put the parties on a program like Talking Parents, Family Wizard, a program where they can message each other that's monitored by the court, so that in the event that any messages do want to be introduced at trial, that there won't be authentication issues, and you'll be able to introduce them to show some of this abusive and controlling behavior. Now there's also voicemails, voice recordings, property damage, photos of injuries, audio recordings. Now, one issue we do run into sometimes is that victims, they record these conversations that they'll have maybe when they're being abused, but if the abuser doesn't know they're being recorded, it's not admissible in court. And that's just the Florida law, is that you can't record someone's voice without their permission. So we do run into that issue sometimes. So make sure that that person knows that they're being recorded. And now, obviously, we have hospital and medical records, but make sure you get a business records affidavit. Otherwise, it's hearsay. And the most important evidence we have in these cases is often their testimony, the petitioner or the parent themselves. Domestic violence often occurs behind closed doors. So there aren't always witnesses, there isn't always evidence, especially when it's the type of coercive control we're talking about, where maybe they're smart enough not to put it in writing, right? And so it's just going to come down to the petitioner testifying as to what they've gone through. And hopefully maybe a neighbor, a friend, a family member has seen some of this behavior, even if not directly, but seen something that caused them concern, and try to introduce their testimony. And obviously there's always the child testimony. Now, there's obviously a lot of difficulty with having a child testify. You'll need to request special permission from the court if you want the child to testify themselves. And obviously courts generally don't want the child to be involved in the case if it's not necessary to do so. There's also the option of having child victim hearsay be admitted. Again, you do need to request special permission from the court in order to do that. And obviously the child has to actually be the victim in that case, not the parent. But these are all things that you should look into now, even more so than before. I mean, these things were always important to do in cases, but now the legislature has confirmed and told the court to take these things more seriously, because these things do lead to we know that these things lead to more violent situations because we've seen it. I know that was a lot, but I was just kind of giving you the general information of how it's going to apply, I think. I don't know if we have any questions, or if Mr. Grieco wants to piggyback off that, or.
No, I'm good. That was impressively comprehensive. that covered it all.
Thank you both very much for that. That's all very, very useful information, both on how we got to where we're at and where we're going and how we do hearings. We don't have any questions in the chat yet relating to this specifically.
I'm seeing some comments.
There's one that just came, and if either of you want to address, how can they show that the abuser knows they're being recorded?
Well, sometimes, they are saying like, okay, record me, I don't care. Sometimes they openly just say it. A lot of times it's like, you can tell from the angle in the video that the phone's being held outward as opposed to like,
right. There's kind of two ways to do it. Florida wiretapping law, obviously we're a two-party consent state. Whether it's audio or video, if it's strictly audio, you want to be able to tell them, you can even whether they know or not, whether they say something, you can literally be the recorder and be like, hey, I'm letting you know right now, I am recording you. So if they continue to talk after you say that, that is consent. They have now provided consent because they've been told that, and they continue to talk. You can tell that you can establish that. That's number one, whether it's on audio and or on video, you just use the totality of the circumstances. The other part of it is, if you're in an area where somebody would not have reasonable expectation of privacy, there's a line of case law that essentially says that if you're in a public place and you're somewhere where you would not have a reasonable expectation of privacy, where if it's just audio and you can hear people around, you clearly can be overheard in any way, you are, by having any sort of conversation, you are consenting by default. So there's a line of case law on that, because otherwise the recording itself is actually a crime.
Right.
So it is a criminal offense to record somebody without their consent, video or audio. It's a felony violation of Florida wiretapping law. So it's a delicate dance. You just need to make sure that, you know, if you're doing it, that you immediately say, I'm recording you, or they identify that they're recording, or if it's in a public place where the average person would not have a reasonable expectation of privacy. So I know that's a long answer, but
No,
I can tell you, I've not only have had to deal with it as an attorney, I've had to deal with it. If you could probably Google where I'm dealing with it right now as part of my political campaign.
Yes, and I believe the only exception is when you're recording a violation of an injunction.
That's new.
That's new. So
that's very new.
Yeah.
And yes, that's where you can do it if it's something that could trigger an injunction violation on a
right. We already have to have the injunction, so it's a little different, but yes.
Right. If there's a temp or a perm, temporary injunction or a permanent injunction, that changes the rule. That was a very that I think that just happened last year, actually, because I know that had come up several years, and there was pushback on that as well.
Agreed. Yes. And I've definitely had situations where they were being recorded inside of the petitioner's vehicle. So the respondent had no expectation of privacy within the petitioner's vehicle, who had like a dash camera situation going on in there, especially these days. Like, we all have to know that there are cameras everywhere and recording things everywhere. So yes, thank you for bringing that up, the expectation of privacy exception.
And it's great to see that Allie is actually watching along, and she's been commenting in the webinar chat. So it's great to see that she's involved, and she's staying involved to make sure that the law is actually being followed. And if folks can see in the chat, she's talking about how judges are pushing back on this and not understanding the law. And part of what we tried to do in the first round of this legislation was also to include training for judges, for the judiciary, to make sure that they were fully informed as to the application of this law versus just getting an update, the annual update at the judicial conference. So clearly, just from Allie's relating anecdotally, that I guess that there are judges that are kind of blowing this off, saying that there has to be an injunction in place in order for this to be triggered, which is obviously that is not a condition precedent in order to conduct this analysis.
And I just want to clear, talking parents, I see that you commented that it's not monitored. It's not monitored in real time by any means, but if you do have to introduce the messages at trial, you don't have to worry about authentication issues, like the person saying, I didn't send that message, that wasn't me. But yeah, no, it's not being monitored in real time.
Well, and being in private practice, I would just add to the issue of talking parents and it being monitored, that even though it's not necessarily automatically monitored in real time, if you have a case, I know many of our participants today are lawyers. If you have a case where you have a guardian ad litem or a social investigator or a parenting coordinator or some third-party professional that either by court order or agreement has been given access to those records, they can log in as as a third-party participant, they can have their own account and they can log in and they can see what's happening. So that's another good way to use that. There was a question that was put up into the questions section where one of our participants would like your opinions on, in your opinion, how is Greyson's law going to impact child protection investigations and the Chapter 39 injunctions? If either of you have any knowledge or opinion on that.
I mean, I mean, I hope that it impacts their investigations. I hope that they take it seriously. I think already the investigations would take issue if just the parent was being abused by having the children in the home, even if the children themselves weren't being abused, that parent could be seen as like failing to protect the child by allowing them to stay in the home with the abuser. So I feel like this will only increase the amount that they take that seriously. I don't know if Mr. Greco has a comment on that.
I don't. That's above my pay grade.
Yes, I mean, I wish that I knew a little bit more about how those investigations happen. I do know that when we do want them to talk about their investigations, like we do have to request when you subpoena them, they will file a motion with the court for the court to determine whether or not they can divulge the details. And the court has to find that it's like there's an issue which needs resolution that it would be relevant to. I think I'm butchering a little bit the language, but that's basically what it is. And I would argue that this law change only makes those types of investigations more relevant. And so therefore, I think maybe you'd have a better chance at convincing the judge to allow in the investigative report. That's what I think. I haven't gotten a chance to do it yet, but that's what I'll try.
Okay, thank you very much. If people have questions, there's both a question and answer section on the webinar that you can type your questions into, or you can put them right into the chat. And we have another question in the chat, and that question is, how do you get police and CPS to intervene with the law because they won't in family court? How do you advise your clients on that?
I mean, I always advise my clients that if they are concerned about their child's safety in any way, that they need to report it. That in addition to maybe bringing it forward in court in motion practice, but like the first step is like, if you think your child's in danger, you have to report it. Now, in terms of getting them to actually intervene, I don't know if you mean like intervene in the actual case. That they're not going to do, but in my experience, they will open an investigation even if there's a family case going on, if it's the merit for it. An emergency pickup order is a motion that you can file. So if you call them and they say they won't do anything without it, you can file a motion for an emergency pickup order. That is always an option, but you are going to have to establish, right. So those are the options. I mean, some of it is just you hope that you get an investigative officer that will take the case more seriously. You obviously can always report it to the police if you believe that it amounts to criminal abuse. The issue sometimes is that corporal punishment is allowed. And so it's about whether or not it exceeds corporal punishment, whether it's reasonable based on the circumstances. It's not an easy answer. I wish that I could say that I could give you a how-to to make sure it works every single time. It's not going to work every single time. But these are just some methods for you to take and for you to recommend to victims. Just they have to report it, and hopefully somebody listens. And sometimes, yeah, that's all I can say.
So Sheila, there was a question by Sheila in the chat about why red flag laws weren't used in Greyson's specific case, and I was just texting with Allie. They did not know that he had a firearm, so that was not something that's not information that was available, and that was not requested or required to be disclosed in mediation. And because there was no injunction, none of that really was ever raised. So that was an unknown quantity at the time. But obviously, there's a potential that a red flag law trigger could have been used as another tool in the toolbox, based upon the threats and based upon them being credible threats.
Yes, and so that's what I would say is I always recommend go file the petition. If it gets denied, it gets denied. It's without prejudice. You could always refile if more incidents occur, but you don't know unless you ask, right? So I would always just say file the petition if you feel that you're in danger. And include any and all incidents. Like, I would recommend including the whole history. Sometimes when people go to file their petitions, like the clerk or somebody there who is well-meaning, but will tell them like, oh, just include the most recent thing, whatever's happening. But I would recommend, especially in a case where you're establishing coercive control, that you show like the cumulative effect that it's had over the course of the relationship, to legitimize why you're afraid it's going to escalate, because sometimes your abuser better than anyone else, right? Like, when it's going to get bad. I'm using the you as in the victims. So they just need to establish in their petition, like, as completely as possible, the reason for their fear.
I saw a question in the chat that I can actually directly address, which was, if all of the circuit court judges have been told and received a copy of Greyson's law. And I can't speak to any other jurisdictions, but I can tell you with certainty in the 17th that they have seen it, that the family bench has seen it. They have had lectures on it. They have had CLEs on it. We have had monthly lunches on it. And just as recently as last week, we had a full day of nuts and bolts. And that program focused on not just Greyson's law, but all of the legislative updates, so that everyone, the bench and the bar, everyone who chooses to participate has seen these things, because they're all important.
Right. So I'm down here in the 11th, and I don't know the answer to that question for purposes of Miami-Dade, but you've now triggered me to text the administrative judge for family law, who's also one of my constituents here. So I'll see what she has to say. But I hadn't seen anything, but I'm also not in, any of the family law listservs. I'm on the criminal listserv. So I'll find out though.
One thing I realized I forgot to mention is in these divorces and paternity cases, now that the judges are required to evaluate all of the factors, and now that they are required to consider if they have reasonable cause to believe they're in danger of domestic violence, if the court does hear evidence of domestic violence, they must make specific written findings showing that it was considered. So just make sure that your judge make some written findings about that. And obviously you got to present the evidence if you want them to make the findings. But yes, I was at that seminar on Friday. So yes, I can confirm. And a lot of our judges in our circuit are honestly new to the bench. And so they haven't even worked with the previous law. They've only worked with this law. So it's not like going to require a retraining in that regard.
Great. If anyone else has questions, it's a good place to put them. I would echo what Shayna said, in that a judge can't ever, this is both for the practitioners who are listening or anyone else, a judge can't give you what you don't ask for. That's one of the first things we as lawyers all learned about pleadings, back in law school. And it's just as true wherever you are in your practice and whatever it is you're asking for. Ask for what you want. So make sure you're filling your pleadings with both the language, now that we have the new statute, the language from the statute, and in your prayer for relief, what you're asking for. That's the way to get it done.
Right. And I would say,
Shayna, is there any specific language you guys are using in your petitions now, relative to this change in law?
So we we frequently would already include in our petitions when they were a victim of domestic violence, that as a basis for decision-making authority, at the very least, if not sole. But I would, especially if it's a situation where it's just reasonable cause to believe, I would include that language in there instead. Previously we would say they are a victim of domestic violence. Now we can include that they have reasonable cause to believe. I would not include too many facts in there in terms of what the actual allegations are, just because your divorce pleadings don't need to be quite that detailed. I would save that information, all of those details, for the actual petition for injunction that you file, which may or may not be granted, but you should still file for it, even if that's going to be something you're going to be claiming in your divorce case and you really are in fear, then clearly you should file for the petition for injunction as well. And like I said, I would recommend with your client, if your client says that they feel they're being controlled or that feel threatened, I would pull out that power and control wheel and I would go through all of those segments and ask the victim or your client about whether or not that's going on with them. And because sometimes a lot of these clients, they don't even realize some of the ways that they're being victimized, right? Because it's become so normalized to them, right? That's all they know. And then sometimes when you start going through and asking them things that are on that wheel, it's like the first time it clicks for them, they're like, oh, this is not a normal relationship. Like I shouldn't be feeling like this. So sometimes you have to ask them the questions. A lot of times they aren't willing to tell you. They might be embarrassed about how they've allowed themselves to be treated. In their opinion, allowed themselves to be treated. So the citations to the case law, it's now in the new injunction forms. There's a new factor itself. If you look at the petition for injunction, it's factor M, I believe. M as in Mary. So that's the citation itself about coercive control.
I keep seeing the question, is there a case? I mean, not one that I know of yet.
Right.
Remember, this is brand new, that coercive control is part of the domestic violence statute and the injunction. Prior, it was specifically excluded. The law prior was that coercive control did not constitute domestic violence.
Right.
So because of that, and that it's a distinct change, we'll see what the cases say and how they define it. But I think it's a great idea when you're exploring this with your client. I've certainly never done it before in my practice, but the idea to take out the wheel and go through that and use those facts as what you plead to show coercive control.
Right. If you want me to share it, I have one right here. Just to show that wheel, even though I'm sure most of us have seen it. Let's see if I can. Oh, I've been disabled from screen sharing. But you can just do a quick Google of the power and control wheel and you'll find it. Because it's like I said, as DV practitioners, when I first started, 5 years ago, that was one of the first things I was shown, in order to be trauma informed when you're talking to your clients, as far as to pick up on things they say that indicate that they're a victim.
Someone has asked what advice you have if they have filed for an injunction on behalf of their client and then the injunction is denied. What do those next steps look like?
You can file a motion for it to be reconsidered, but usually, generally, you just can refile if any new incidents were to occur. That's really the answer. It's denied without prejudice. So you also could refile. Maybe you didn't include certain things. You could file a supplemental affidavit if maybe you only include the most recent incident and there's been previous things. But yeah, sometimes, and sometimes it's the luck of the judge who's reviewing it, right? One judge might review it and think that definitely meets the standard of coercive control, and another might read it and think, I've had crazier exes. I don't know. It just kind of depends on the judge you get sometimes. But the more that you can corroborate it with text messages, voicemails, anything like that, the better, so that it doesn't become a he said, she said, or she said, he said.
Thank you both very much. Thank you for your time today. Thank you for your dedication, both of you, to everything that you've helped us to accomplish, both here in Broward and really in the state of Florida with getting this legislation through, and keeping everyone informed about what to do. Both of you have been a tremendous help today. We appreciate you on behalf of the Broward Bar, and thank you to all of our participants who have logged in to learn more about this update and how to use it in your practice.
All right. Have a good day, everyone.
Thank
Bye,
you.
guys. Have a good one. Thanks for having me.